Good afternoon, everyone. My name's Andrea. I'm a co-director in the Educational Committee, and today I am very happy to announce the presentation for today, which is the pass-through of taxation of S corporations. I wanted to share the CLE course code. It's 8801. And I also had some important announcements before we begin. We have a December 11th CLE. It will be hosted, or it would be presented by Daniel Hudson, and it is the lead up to the ITC. That CLE is titled Planning and Pitfalls in International Taxation. We also have a December 18 CLE presented by Osvaldo Garcia. It is titled The Taxation of Private Trust Companies. We also have the dates for 2025 boot camp. It'll be taking place on January 8th. And we also have the ITC conference taking place January 9th and 10th, 2025. Allow me to introduce our speaker for today, Mr. Daniel Ebert. Daniel focuses his practice on counseling individuals in closely held businesses on tax and operational matters. He's also very well versed in federal income tax matters and working with pass-through entities such as partnerships, limited liability companies, and S corporations. He also assists families and individuals in protecting and passing on their wealth. Please note that we have a question and answer box. Please type in any of your questions in there and he'll be happy to answer them at the end of the CLE. And now we have Daniel with us today.
All right, thank you, Andrea. And thank you all for being here. We're recording this on November 13th, 2024, the day after the University of Kentucky Wildcats beat Duke in the Champions Classic. So go Cats. So whether you're here now live or you're watching this later in preparation for the Florida Bar Tax Certification Exam, thank you for being here. Welcome. This is mainly focused as kind of a primer or a study tool for the tax certification exam. You know, I took the exam in March of this year, and entity selection and any taxation is a huge part of it. You know, it's essentially half the points on it. So you really have to know it thoroughly. So today we're going to really focus on S corporations, but also compare and contrast C corporations and partnerships. So generally what we'll talk about is, you know, what is an S corporation, the requirements to qualify as an S corporation, the tax impacts of operating as an S corporation, how that S corporation status can be lost, various relief procedures, and things you should consider in terms of entity selection. And just going from a broad perspective, what is an S corporation? You know, Subchapter S of the code came into being in 1958. So it's been there a while. But if we think about, well, one thing quickly, Andrea put a plug in for the International Tax Seminar. And specifically, I'd encourage everyone to go to the boot camp. I'm not sure if Sean Wolf is presenting at it this year, but he's presented a lot in the past. And I think he does a great job of always going back and saying, well, what is the situation, the perceived problem that caused Congress to enact what they thought would be the solution? What was the thing that got us to where we are today? And with S corporations, if we go back and we think about, you know, for entity selection, for tax purposes, you have C corporations, S corporations, and partnerships. And if we go back to kind of when Subchapter S was enacted in the 50s, you had C corporations, and those provided the shareholders, limited liability for the company's, debts and obligations. But that came at the price of the double tax system. So, the C corporation itself is subject to tax, and then as the dividends are issued out to the shareholders, subject to tax again. There were also, general partnerships. And, we still have those today, but the drawback is each partner has unlimited liability. And also, there were limited partnerships at that time. And limited partnerships, they provide the limited partners with liability protection, but especially back at that time, they were really focused on passive businesses. That liability protection was premised on the limited partners not being active in the operation of the business. So if you were going to operate, if you were going to be a part of an active business, you had pass-through taxation of the partnership structure, but unlimited liability, or you had the C corporation double tax. So this was kind of a solution to that. The reason behind it was, Congress said they wanted to make it possible for businesses to select the form of their organization and have it not entirely dependent on what's the tax consequences. And subchapter S in 1958 is, almost unrecognizable to what it is today. So it's changed a lot. It kind of got a lot closer to what it is today in the 80s and 90s. But throughout that whole process, the fundamental purpose of subchapter S, which is to eliminate the corporation as a taxable entity and provide a system under which the operating profits of a qualifying corporation is taxed directly to the shareholders, that remains unchanged. Part of the change in subchapter S and S corporations isn't just in the code, but also their popularity. They have become the dominant business structure in the United States today. The most recently available data from 2023 suggests there's over 5.8 million S corporations. And we can really see the growth potentially, especially in the 80s up to today. Like in 1980, only 13% of business returns were S corporations. And now, it's 38%. And if you look at C corporations in 1980, it was 53%. Today, they're down to 35. And, of corporations, S corporations are, over 75% of entities that are, for tax purposes, treated as corporations today. But even with their, massive growth in numbers and how often the S structure is used, they still remain, really small businesses. In 2015, S corporations were 27.3% of total corporate business receipts and 22.5% of total corporate net income. They account for over 75% of corporations with less than 500 employees. Almost 90% of S corporations employ 20 or fewer employees. And while they make up over 75% of all corporations, they're still less than half of total corporate employment, less than a third of total corporate payroll. And always to keep in the back of your mind when you're thinking of an S corporation is that, it is not a distinct form of a legal entity like a corporation, general partnership, limited partnership, or an LLC. What it is it's an entity formed under a state's laws that for federal tax purposes is either already a per se corporation under the check the box rules or is, an eligible entity that has elected to be a corporation and subject to subchapter S of the code. So your requirements to qualify as an S corporation, again, on certification exam, this is a very easy thing to test because it's a lot of these are black and white. Is, first, it's got to be what's called a small business corporation. And then in addition to that, it has to have an election in effect under subchapter S. So to be a small, quote unquote, small business corporation, entity must be domestic, not one of 4 types of corporations that are just ineligible. You cannot have a non-resident alien as a shareholder, a single class of stock, and then permitted shareholders, essentially individuals, estates, certain types of trusts and tax exempt entities, and no more than 100 shareholders. So even if an entity meets all those requirements, it's a small business corporation, does not mean necessarily it's an S corporation. It also make an affirmative election to be taxed under subchapter S of the code. And when you think of small, we talked about how most of them truly are small businesses. The small doesn't relate anything to the size of the business, how many employees, or how much income or receipts it has. It's really, the small refers to the number of shareholders. So first requirement, being a domestic corporation, has to be formed in the U.S. or territory. And this includes associations that elect to be taxed as corporations. And if a corporation's formed outside the U.S., even if 100% of its business operations are conducted inside the U.S., won't qualify. Ineligible corporations, you're not really going to come across this very much at all, but financial institutions that use a particular method of accounting, and here it's mostly going to be like regional and local banks, insurance companies, discs like IC discs, which are kind of these exporting incentives, and taxable mortgage pools. The requirement that no non-resident is a shareholder is very important with S corporation, and it's a big difference between C corporation structure and partnership structure. That to be a small business corporation, no shareholder can be a non-resident alien. And when we're looking at non-resident alien status, is the person a citizen of the U.S. or a resident under lawful permanent residency, the green card test, the substantial presence test, or the first year election. So, that status could change, if they're not U.S. citizens and they're here under substantial presence test. While this is a requirement, it can't be a non-resident alien. Non-resident aliens, while they can't be shareholders, they can be beneficiaries of electing small business trusts that we'll talk about here later, which those can be shareholders. And then, one question that was out there for a while and seems to be resolved is, well, what if you have a non-resident alien? Can the non-resident alien and the S corporation form a partnership to carry on the business? And I mean, the answer is, it seems to be yes. You get into the withholding issues at the partnership level when you have the non-resident alien partner. The one class of stock requirement is very important for S corporations. In terms of the qualifications, there's a lot of relief provisions when it's not met. But as classification, permitted shareholders and one class of stock are really where most entities either qualify or don't for S corporation status. So to be a small business corporation, the corporation can't have more than one class of stock. I mean, what does that really mean? I think we'd understand it if it was, class A, class B. That seems pretty clear on the face of it, but not necessarily. So the regulations say that corporation is considered as having more than one class of stock if the shares of outstanding stock do not confer identical rights to distribution and liquidation proceeds. So it also goes on to say, voting differences are fine. So if you have voting stock and non-voting stock, it's not considered two classes of stock. The test is, does each share have equal rights to distribution and liquidation proceeds? And it's important, rights, not necessarily in actuality. So the determination of whether all outstanding shares confer these identical rights to distribution and liquidation proceeds is based on looking at the governing items of the entity. So the corporate charter, the articles of organization or incorporation, bylaws, operating agreement, also applicable state law, and any binding agreements relating to distribution and liquidation proceeds. So it's important that whatever the governing instrument of the entity is, if it's seeking to qualify as an S corporation, it can't have items in it, provisions in it that are in conflict with this requirement, that all ownership interests confer identical rights to distribution and liquidation proceeds. So, when you're talking about new S corporations, a lot of times they're formed as limited liability companies on the state level. Again, S corporation is just a state entity that's then eligible to make an S election. So, you'll come across these LLCs where, their operating agreement has, essentially, the, LLCs by default are usually partnerships if they're multi-member. And so the operating agreements will have this 704B, the substantial economic effect language. And that disqualifies it, or most people think that disqualifies it as having a single class of stock. And not only, especially in my opinion, is it what's in the governing instrument, but also what's not in there. So, sometimes people, as a way to fix it, they'll just take out the requirements that the 704B language or the requirements to make distributions or liquidating distributions in accordance with capital accounts. And the test is looking at not just what your governing instruments are, but also looks at the state law. So, specifically for me, I think you have to also affirmatively turn off any provisions in the state law that would conflict with the S election. So here in Florida, I think it's not enough to just take out the 704B language, but especially if it's an LLC, to modify what the default provisions of, 6050404, which is sharing of distributions before dissolution and profits and losses, which is in accordance with transferable interest, and 605.0710, which is disposition of assets and winding up, because that is, gives first priority to returns of capital. So I think those have to be turned off rather than just not dealt with, because under the LLC Act, if the operating agreement does not do otherwise, then the default provisions are in play. And really, for the certification exam, about the one class of stock. There's a lot of particularities that I'll leave for you to investigate on your own. A lot of them deal with debt instruments, options, convertible debt. Restricted stock. This is another big difference between partnerships and C corporations. As an issuing property for services is generally taxable, and if it's substantially non-vested, then it can be delayed. For when you're looking at is there more than one class of stock? As long as the issued shares are still substantially non-vested, they're not taken into account. An 83B election is made. They are. Buy-sell agreements are not implicated in there being a second class of stock unless a principal purpose was to avoid this requirement and the purchase price is just way out of line with fair market value. And proving if the principal purpose was to circumvent the one class of stock rule is a high hurdle. There's a safe harbor that's good to know about of bona fide agreements at death, divorce, disability, or termination. And it talks about purchase. It doesn't talk about the purchase price needing to necessarily be fair market value. This issue, disproportionate distributions, has probably caused more confusion, in my opinion, than a lot of other S corporation requirements. In that, disproportionate distribution. So if the one class of stock is based on every share have equal rights to distributions and on liquidation. A disproportionate distribution is something other than that, essentially, whether it's in timing or amount. And so the only real pure guidance that is out there is a regulation that says that any distributions, actual, constructive, or deemed, that differ in timing or amount do not per se violate the one class of stock requirement, and they're to be given appropriate tax effect in accordance with facts and circumstances. Okay. But that's still left people, or to today, even leaves people unsure. But I think the disproportionate distribution aspect is the fear is not warranted. You know, we'll talk about this more later, but Revenue Procedure 2022-19 came out, and the IRS just flat said, you know, as long as your governing instruments don't provide for disproportionate distributions, they provide it's a one class of stock, then we're not going to treat any disproportionate distributions as violating the one class requirement. Earlier this year, there was a tax court case that was decided, and it was a memorandum opinion, which, you know, technically means that it's not cited as precedent. And, you know, memorandum opinions are when the tax court's really saying, you know, this is black letter law. Everyone knows we're not, you know, we're not forging any new ground. We're just applying facts to this basic fact we all know. And in that, the holding of that case, Maggard v. Commissioner, was that, you know, disproportionate distributions by themselves do not change a company's S corporation status. And we're going to talk about that case just briefly because it's the example of why this is probably overblown. So in that case, this was an engineering company, and their governing instruments provided for equal rights on distributions and liquidation. So it met all the S corp requirements. 100% shareholder, ended up selling to partly to two other guys. So he owned, the original guy owned 40%, and the two new guys owned 40 and 20 each. And these two new guys just froze them out entirely. You know, they wouldn't let them have access to the books and records. They essentially said, don't come to the office. They made all the distributions to themselves for years, didn't even provide him with information for his tax file. He got no distributions. And, you know, eventually he sued him in state court. Like, it was clear cut, like fraud, horrible people, everything. So he eventually, you know, files many returns. And his argument was, well, look, these guys were making all these disproportionate distributions. It violated the S election, reverted to the corporation. I'm not subject, you know, IRS, you can't tax me on this income that I never received. And the tax court, you know, had, look, we feel sad for you, we empathize with you, but your governing instruments, your, you know, articles of organization, your operating agreement, they met this requirement of the one class of stock. And even though all the distributions went someone else, you never received a dollar of it, it didn't violate the S election. You were still an S corporation, and you were still subject to tax on the allocations of income, even though you did not receive it. So again, I think the concern is really misplaced. Another reason is if you go look at the proposed treasury regulations on this back in 1990, they're very draconian. You know, they say if you make a disproportionate distribution, violates the S election, you know, you go to jail, everything, just the worst of the worst. And then in 1992, when the final regulations were issued, IRS walked that back entirely. They said, we received a lot of comments. We took your comments into consideration, and they removed all that language and just went with the language of appropriate tax. So the other easy area to test on this, as well as the other easy area where entities either qualify or don't, are the permitted shareholders. And to be a small business corporation, you can't have anyone as a shareholder who's not an individual, although remember, can't be a non-resident, an estate, certain types of trusts, certain types of tax exempt entities. So that means as a shareholder, can't be a corporation, can't be a partnership, or one of these ineligible types of trusts. Individuals, you know, they're the most common shareholders in S corporations. Again, can't be a non-resident alien. estates of individuals, also estates of a bankrupt. So if someone's going through bankruptcy, the bankruptcy estate is an eligible shareholder. The trusts that are permitted. Grantor trusts. Grantor trusts after the death of the grantor. Certain, most testamentary trusts, voting trusts, qualified subchapter S trusts, electing small business trusts. Foreign trusts are not permitted to be shareholders, even if they would otherwise be, grantor trust or meet one of these other requirements. Grantor trusts, subpart E. And these include not only grantor trust where the grantor is, treated as the owner of the trust for tax purposes, but also a beneficiary deemed grantor trust. Only one individual can be the grantor, and has to be the entirety of the trust. It can't be partial. Former grantor trusts, so trusts that were used to be grantor trusts, but now they're not. There's a 2-year period once that grantor status terminates where the trust remains a qualifying shareholder. But the important part here is that these former grantor trusts only remain qualified so long as the reason why the grantor trust status terminated was due to the death of the grantor. If, for example, someone has a substitution power and they're just tired of being taxed on the income of the trust and they relinquish the substitution power, it's not a qualifying trust anymore. It's formally a grantor trust, but it's formally a grantor trust for a reason other than the grantor dying. It could still meet the parameters for another type of qualifying trust, but it won't qualify as a former grantor trust. Testamentary trust. So a testamentary trust, which receives S corp stock after it's been transferred, is a permitted shareholder for 2 years following the date it receives the stock. And so, we know that an individual's estate is a permitted shareholder. So if the individual's will bequeath stock to a testamentary trust, it can be held in the testamentary trust for additional 2 years. And I didn't talk about this with the estates, but the period of how long the estate's a permitted shareholder, there's no set requirement. It's within, the estate has to be administered within a reasonable time period. There is some case law where it was for many years, but for no reason, essentially, and it was deemed to have converted into a trust under subchapter J. But, if there's an installment plan under 6166 for estate taxes, it's fine for the estate to remain an eligible shareholder during that period. And one way that plays in with testamentary trust is, 645 allows a decedent's estate and the trustee of, the decedent's formally revocable trust to elect to treat the trust as part of the estate. And that includes if the trust owns shares in an S corporation, it's the estate that's deemed to be the shareholder. And what this allows is it just allows you to push that time out further, where, the estate's deemed to be a shareholder. This election lasts generally ends at 2 years of death if there's no requirement to file estate tax return. And it in theory, it goes on until 6 months after you obtain a closing letter. But what does that really mean now that IRS really doesn't issue closing letters anymore? And then once that 645 election, once that period ends, it's deemed to be a transfer to a trust. So then you have that period of time to a testamentary trust. So then there's that additional period of time where the recipient trust is a permitted shareholder. Voting trusts are permitted shareholders. You just have to look through to make sure all the beneficiaries of the voting trust qualify. Qualified subchapter S trusts, QSSTs, these are very important from an estate planning perspective. It's a permitted shareholder, but it also has to make a timely election. And to be a QSST, it requires that the trust either distributes or is required to distribute pursuant to its terms all the trust income to one individual who is a United States citizen or resident, and then the terms of the trust have to require that during the life of the current income beneficiary, there can only be one beneficiary, that any corpus distributed during that income beneficiary's life has to go to the income beneficiary, that the income interest of the current beneficiary terminates at death or on termination of the trust, and that if the trust terminates during the life of the current income beneficiary, all the assets have to be distributed to that beneficiary. And when we're talking about income here, it's fiduciary accounting income. It's trust income under 643B, not the broader, IRC 61 all income. So, if the QSST sells its S shares, the QSST doesn't have to distribute that out to the beneficiary because it's not trust income, it's trust principal. And in addition, while all the trust income has to be distributed out to the beneficiary who's taxed on it, if it's a sale of shares, it's the QSST, it's the trust, not the beneficiary, who's subject to the tax on that. And in addition to meeting all these requirements, has to make a timely election. And this election is separate from the subchapter S election. The election is made by the income beneficiary, not by the trustee. Has essentially 2 months and 15 days, pretty much 75 days, in order to make the election and have it retroactive to the initial start. If the QSST holds shares in multiple S corporations, it has to make multiple elections. So for every S corporation in which the QSST has shares, it has to make its own separate election. Once made, it's an irrevocable election. This is important because, a lot of times these QSST trusts can qualify as QTIP trusts, so it comes in very frequently in that instance. The other type of what I'll consider really your common estate planning trust is you're electing small business trust, and ESBT also has to make a time of the election. ESBTs are very different from QSSTs, though. So an ESBT's requirement is, it can't have a beneficiary other than an individual, an estate, or certain tax-exempt entities. No interest can be acquired by purchase, so no beneficiary can buy into an ESBT. Timely election, and then, certain prohibited beneficiaries, primarily, charitable and remainder trusts. And with an ESBT, the portion of the trust consisting of the S stock is treated as a separate trust, and all of the income attributable to that S corporation stock, including gain on its sale, it's just taxed to the trust. So, and at the highest rate. And then, the beneficiaries of the trust, when they receive distributions, they're from the S corporate that are attributable to the S corporation stock, they're not taxed on that. And these ESBTs are the only avenue in which a non-resident alien can be they're indirect, but the closest to being a direct participant to an S corporation. Timely elections is pretty much the same timing requirements as a QSST, although here the big difference is that the election is made by the trustee, not the beneficiary. Certain tax-exempt entities, 501c3s, can be shareholders in S corporations. Certain trusts under 401a, that's really designed for ESOPs. Nominal stock ownership. So, if someone's an otherwise non-permitted shareholder and they hold stock as a nominee for someone else, either an agency, guardian, or custodianship, then it's the individual on whose behalf the stock is being held who is treated as you determine to be the permitted shareholder. Generally, it's someone's holding it as a custodian for a minor. One other thing, so these aren't shareholders, but we said, a corporation partnership can't be shareholders in an S corp, but an S corp can be a shareholder or a partner in a corporation or a partnership. And so if we're looking at a corporation, and specifically when the S corporation owns 100% of the stock in another corporation, it can elect to treat that subsidiary corporation as a qualified subchapter S subsidiary. And if that election's made, it's treated as if the Q sub isn't a separate entity. It's essentially a disregarded entity, and all of the assets, liabilities, and tax items are treated and reported on the parent's return. And this is also important to note, this is just for federal tax purposes. So someone asked me today that a S corporation with 3 Q subs, and whether for Corporate Transparency Act purposes, if you could aggregate them for meeting the large entity exception. I don't think so. The regulations, they point out that it's for purposes of this Title 26, and FinCEN is Title 31. And I think there's an FAQ also that's indicating that. Okay, so you have a small business corporation, meets all the requirements, is an S corporation. Not yet. So it still has to make a valid election to be an S corporation. And that election has to be filed either anytime during the taxable year if you want it to be effective the next taxable year, or if you want it to be effective retroactively during the current taxable year, you have to do it by the 16th day of the 3rd month. So if it's on a calendar year, pretty much March 15th. And if you're kind of late on, if you're getting to that March 15th point, if you intend to file an election for that current year, the entity must meet the eligibility requirements for each day during that period. And all the shareholders owning stock in the corporation on or before the date the election is filed have to consent. This includes people whose ownership interest changes. So if you were a shareholder January 1st to February 1st, but you're not after that, you still have to consent to the election. Basically, anytime the election is filed after that 2-month, 15-day period, it's only going to be effective prospectively the next year. The election's made on Form 2553. Officer of the corporation has to sign it. All persons who are shareholders on the day it's effective, and in the interim period, if it's retroactive, have to consent. And particularly if it's an LLC, so if the entity isn't formed as a corporation, it's formed as an LLC, it has to be a corporation to then make a small business corporation to then make the S election. So nowadays you can just file the Form 2553 to both elect to be treated as an association, taxed as a corporation, as well as to make the election to be an S corporation. Back in the day, you had to file each form separately. The thing to remember on that is, once a corporation has made a valid S election, it's an S corporation. And if it ceases to be an S corporation, it reverts to being a corporation, taxed as a corporation. So if you're an LLC, you make the S election, and then you later violate your S election, you're a corporation. If the initial election is defective, however, so if you're an LLC and you file your initial Form 2553, electing both to be treated as an association, taxed as a corporation, and an S corporation, if that election is invalid, you just remain what you were. Default status, usually a partnership or perhaps a disregarded entity. Once made, it's in effect until it's terminated, either voluntarily or by failure to maintain S requirements. And once it's made, there's no requirement that someone new coming into the organization has to consent. So once the S election is in place, even if shareholder turnover is 99%, no one has to consent after that. When the election is terminated, then generally it's a 5-year period before a new election can be made. And we're going to talk about this towards the end, but there's tons of relief avenues for when the election doesn't go how you thought. All right, so tax impacts of operating within an S election. As we talked about, an S corporation is a corporation with an additional layer of subchapter S. So, if you spend any time with me from Kentucky, we've probably had a bourbon together, and I've probably told you that, all bourbons are whiskeys, but not all whiskeys are bourbons. Same way, like all squares are rectangles, but not all rectangles are squares. So all S corporations are corporations, they're C corporations, but not all C corporations are S corporations. So, to the extent not inconsistent with the provisions of subchapter S, the provisions of subchapter C apply. And so that means that, issues on formations, property contributions, redemptions, distributions, liquidations, reorganizations, all these things, you can really only determine what the tax impact is by looking both at subchapter S and subchapter C. But it's not all the times that easy, because there's also a lot of instances where certain code sections that apply to C corporations don't apply to S corporations. The big example would be 1363B says that the S corporation, determines its taxable income in the same manner as an individual. Well, what does that mean? That means that the dividend received deduction, which is provided to corporations, doesn't apply to S corporations. And of these instances where the code otherwise is going to treat S corporations differently than corporations, sometimes it'll treat it as an individual. Other times it's treated as a partnership, particularly for fringe benefit things, a lot of international tax issues as well. S corporation's taxable year has to use a permitted year, which is essentially either calendar year or a good reason, a business purpose reason. Most S corporations use a calendar year. If you have a natural business cycle where 25% or more of the S corporation's gross receipts in a 12-month period are recognized in this 2-month period, you can have that be the ending of the taxable year. But most S corporations use calendar year. So what the S election does, back to our why was it created? It does not eliminate the electing corporation as an entity for tax purposes, but it does relieve the corporation from federal income tax liability from most tax items. There's 4 exceptions that we'll get into in a second. And under Florida law also, Florida taxes C corporations, does not tax S corporations unless the S corporation, has incurred one of these 4 exceptions. And I've really only found statutory authority for 2 of them, but in theory, any of these 4 exceptions. And the 4 exceptions are, 1, gain recognized on property attributable in appreciation of an asset in the hands of a C corporation for a period of 5 years. So that's either 5 years after a C corporation converts to an S corporation, or 5 years after, an S corporation might acquire some appreciated assets from a C corporation in a reorganization or liquidation. One of the things to really watch out for there is collection of cash basis accounts receivable after electing an S election. And this is something that's very easy to test on. It's just a simple, are you going to recognize this? Additionally, when there's passive investment income exceeding 25% of gross income in a given year, and the entity has earnings and profits, which means it was previously a C corporation or acquired a C corporation. These last 2, I've never seen them, but recapture of an investment credit taken when it was a C corporation, LIFO recapture, that could be a little more applicable. LIFO recapture when the corporation recognized in the last year was a C corporation. But with all 4 of these, and particularly the 1374 gain on appreciated C corporation property and the passive investment. But none of these exceptions are going to apply if your entity has no history of being a C corporation or doesn't reorganize with a C corporation. 1363B says, you determine your S corporation's income in the same manner as an individual with some exceptions. Here you have your separately stated items, your deductions, personal exemptions, charitable contributions that are operating losses aren't allowed. Those are, if there's charitable contributions that are operating losses, those are passed through the shareholders. When the S election is in place, essentially all tax elections are made at the S corporation level. Your selection of your tax year, method of accounting, whether it's the entity's opting out of installment sale treatment. The one that really comes up, though, that isn't of these 2 is the election whether to take a credit or a deduction for foreign taxes paid. That is made at each shareholder level. The fundamental premise of subchapter J is to treat the S corporation as a conduit passing through its income, deduction, losses, and credits. So, similar to a partnership, its tax items are divided into two classes: separately computed items and non-separately computed. Each separately computed item is going to be passed through on a per share per day basis. Examples of those are your capital gains and losses, 1231 gains and losses, charitable contributions, tax exempt interest, foreign taxes, investment interest and expenses, depreciation, and then your non-separately stated items, which are all lumped together and passed through. And these separately computed items are allocated in proportion to stock ownership based on all the issued or outstanding shares. So remember, you can have voting and non-voting stock, but they all have to have the same rights to distributions. The character of these items are by and large determined at the S corporation's income. Only exception is if you're intentionally contributing non-capital gain property, capital loss property to the S corporation, and was formed for that for the reason of converting the character of that. So the deductions and losses also pass out to the shareholder, and they're subject to a limitation on the shareholder's ability to realize them based on basis, and then also at-risk rules under 465 and passive activity limitation under 469, and it's in that order. These are all applied at the shareholder level, but it's basis limitation, at risk, then passive activity. S corporation has to file annual return 1120S showing its income deduction, names of shareholders and their holdings during the year, the amount of distributions, and has to provide K1s to its shareholders. And each shareholder has to report these tax items consistently with the S corporation, or they have to alert the IRS of the inconsistent treatment. And if the shareholder doesn't, it's a mathematical change, so it's not subject to assessment procedure. So shares in an S corporation are initially determined same way as shares in a C corporation. And then the basis goes up and goes down as income items are allocated to the shareholder and as loss and deductions are allocated and distributions are made to the shareholder. And these basis adjustments are in theory made on a per share per day basis, but they're really made at the end of the corporation's taxable year. But if a shareholder disposes of any of its S corporation shares, doesn't have to be all of them, any of them, at any point during the taxable year, those basis adjustments are deemed to occur immediately prior to disposition. And the Form 7203 is where shareholders track this, and it's not something that has to be filed every year, but it's good practice procedure for the shareholder to constantly track that every year. The adjustments are made in a certain order. First, increases for additional capital contributions by the shareholder and increases for the S corporation's income items, including tax exempt income, brings the shareholder's basis up. Second, distributions brings it down. Third, decreases for non-capital, non-deductible expenses. And then finally, fourth, decreases for the S corporation's losses. There's an election that can be made to reverse a couple of those. And so as the shareholder's basis is reduced on distributions or allocations of losses, once it reaches zero, the shareholder can no longer deduct those items against his stock. But if there's debt, so if there's debt from the corporation to the shareholder, he can take those losses, has to decrease the basis in these debt obligations. Generally, the shareholder's basis and a debt obligation from the corporation will be the fair market value, so the face value. And then once the basis and the shareholder shares and debt obligations are at zero, stops. It's a suspended loss, and that suspended loss is personal. So if the shareholder sells the shares, gifts the shares, dies, that loss is gone. The only exception is if there's a transfer of the shares in which Section 1041A applies, which is transfers of property sub-incident to a divorce. Once that basis has been brought all the way down to zero, as there's allocations of income, which would bring up basis, first it's applied to the debt obligations, and then once those have been fully restored, then to the shareholder's stock. And here is one of those fundamental differences between S corporations, well, corporations in general, and partnerships. And it's something that is very, very easy to test on, is that shareholders in S corporation, they don't get to increase their basis in their shares for the corporation's liabilities. Whereas, partnerships, if the partnership has liability, the partners can take their proportionate shares of that liability into account in increasing their basis. And for S corporations, that's just not the case. So even if a shareholder personally guarantees an indebtedness of the S corporation, that shareholder won't get an increase in his or her basis until they actually start making good on that guarantee, start making payments. And this is something, it's called the economic outlay doctrine. Virtually every court who's ever addressed this has agreed with it. I will say there is an 11th Circuit case from 1985, which was a great year. That was the year I was born. Fantastic. Where the court said, well, essentially what this was where the shareholder guaranteed the amount they go, well, really, this was a loan to you, shareholder, and then you loaned it to the corporation or contributed to the corporation. But even the 11th Circuit in a case in 1999 kind of segregated that to its facts. So essentially, for a shareholder to be able to increase basis in his or her S corporation shares, they need to directly borrow the money from the lender and then contribute it to the S corporation. Distributions, and I know this talk was marketed as ending at 1. And for those of you that need to jump off at 1, please, this will be recorded. You can watch again later. We're going to continue going past 1, just because this is primarily aimed as a study tool for people taking the tax certification exam. And we're going to end up with, the final portion is comparing and contrasting. Well, what should you consider when you're determining the entity? So distributions, really what you want to think about is, does this S entity have a prior history as a C corporation, or has it, reorganized with the C corporation or not? If you've never had, if it's a brand new S corporation, doesn't have any C corporation history, really not much to worry about. It's pretty simple. Why this
Just
matters.
a friendly reminder, all the participants, if you have any questions, to please drop it in the Q&A, please. Thank you, Daniel. I'm sorry about that.
No, you're good, Andre. Is that distributions from an S corporation aren't subject to FICA. So S corporation pays wages to its employees, subject to employment taxes, subject to FICA, but the distributions are not. So if your S corporation has no earnings and profits, i.e., it's never been a C corporation or acquired a C corporation, nothing to worry about. The amount of the distribution reduces the shareholder's basis in its stock, and any excess over the distribution is treated as gain from the sale or exchange of capital property. There is history of a C corporation or acquiring a C corporation. The S corporation has to establish what's known as a accumulated adjustments account. And what this is, it's essentially a running order of the aggregate amount of adjustments made under 1367 to the bases in the shareholders' shares. And if there is this AAA account, you got to test the distributions that come out of it. And first, to the extent the distributions, constitute what's in this AAA account, you're fine. It just decreases basis in the shareholders' shares, and if it exceeds the basis, gain from capital asset. if the distribution exceeds the balance in the AAA account. So if the AAA account has $50 in it and the distribution is 100, the excess, that 50, is treated as a dividend to extend the corporation's earning profit. So subchapter C 301. Third, any portion remaining after application of the first two steps is treated the same as if the S corporation had no earnings and profits. And so, going back to why this exists, the purpose of this AAA account and these provisions are to treat the corporate distributions by an S corporation as first coming out from its activities while it was an S corporation. And then only once it's distributed out, amounts that are traceable to its history as an S corporation, then it comes out from the C corporation's history. Huge difference between partnerships and S corporations here, but it's the same as corporations. It's distributions of appreciated property. So the S corporation makes a distribution of appreciated property. The corporation recognizes the gain as if the corporation sold the property to distribute at fair market value. So again, subchapter C principles, section 311B, 336A. And that distribution, that gain on that distribution is allocated to all the shareholders in proportion to their stock ownership, not just to the person who received it. So if you think about comparing it to partnerships, 704C, when there's appreciated, the partner contributes appreciated property to the partnership and the partnership sells that property, that appreciation is allocated to the partner who contributed it. Well, in S corporations, that's not the case. If appreciated property goes into the S corporation, and then the S corporation either sells it or distributes it out to a shareholder, doesn't have to be the shareholder who contributed it, that gain isn't allocated to the contributing person. That gain is allocated amongst all the shareholders in proportion to their S shares. Terminations of S elections can be voluntary, failure to comply with S status, this receipt of passive investment income over a certain amount, but that's only if there's a history of being a C corporation. If it's a voluntary termination, it can either be retroactive to the start of the tax year, assuming that the election to terminate is within 75 days, or it's prospective to the start of the next tax year. Voluntary termination, more than 50% of shares. So voting and non-voting, if any one shareholder has more than 50% of the outstanding S shares, that shareholder can unilaterally terminate the S election. Involuntary revocation, anytime it no longer meets the requirements. So very often, yes.
So before we conclude at 1 p.m., the presentation will continue, but this is for all of the attendees. Thank you, Daniel, for everything. I know we're going to continue, but I just wanted to share for those that have a hard stop at 1 p.m. The CLE is 8801 for those that will probably be logging off at 1. And the presentation will be continuing and we'll be sharing the recording later. You're welcome to stay, but for those that have to leave exactly at 1 o'clock, this will be recorded and shared with everyone else. Just a few things for those that might be logging off. We have the December CLE. It's the lead up to the ITC, Planning and Pitfalls in International Taxation. We have a December 18 CLE, Taxation of Private Trust Companies. We have the boot camp happening in January 8th. And then we also have the conference happening the 9th and the 10th. Thank you. And we're just going to continue. I just wanted to give that information. Thank you very much.
Yeah. And for all y'all logging off now, appreciate you being here. And definitely, these CLEs are very informative and helpful, especially when studying for the exam. And particularly, even if you don't practice a lot of international tax, at a minimum, go to the boot camp, because that's a great way to refresh and learn what you need to know for the certification exam. So these involuntary terminations, it's effective the day it happens. And so we go back to our requirements being S corporation. The way this typically happens is S shares are transferred to a non-permitted shareholder. So they're transferred to a non-eligible trust, or they're transferred to a non-resident alien, or to a corporation or partnership. And the termination is effective as the day of that terminating event. And this doesn't matter if it's an accident or it's deliberate. So, a shareholder can just transfer their shares to an ineligible shareholder, and it will blow the S election. Now, a lot of times you'll have provisions in your governing instrument that seek to limit a shareholder's ability to make these transfers that will terminate the S election. And while these don't always work for not terminating the S election, they do provide an avenue of civil liability for the former shareholders who do this. So there's tons of relief avenues for either a initial election which didn't work out, or for a termination. And so it's, the premise of it is all built off 1362F, where the IRS says, if a S election was ineffective or was later terminated, it was inadvertent, and within a reasonable time of figuring it out, people try to resolve it, and that everyone who was a shareholder during this affected period, consents to make adjustments as if the S election had not been terminated, then the IRS says we'll provide relief. But this avenue of relief is by requesting a private letter ruling, which is very time consuming and costly. So in 2013, the IRS issued Rev Proc 2013-30, which really just improved upon prior Rev Procs, but essentially said, look, if you were trying to make an S election, if you're trying to make an ESPT election, a QSST election, Q sub election, any of these types of elections, and you messed up, and you thought it was good, and you had a reason why you messed up. It wasn't just I just didn't do it because I wanted to be treated as a partnership. It was, I in good faith tried, and it could be that I forgot, but I tried. If you're making one of these elections that doesn't work out, you can apply for this relief to where it'll be retroactively, reinstated as if the election was fine. The thing here is that, these initial elections generally have a 75-day requirement if you want to make it retroactive to the first day of the tax year. Here it's 3 years and 75 days. So if the error or the oops was discovered in 3 years and 75 days, it can be retroactively resolved. And what you do is you have to file a statement with tax return. I've never seen one of these rejected, although in theory it could be, saying, here's my reasonable cause, and having the affected persons agree to make any adjustments as if the selection had been in place. That's another area where this can sometimes get not effective. And if you have shareholders who were shareholders in maybe years 1 and 2 but aren't in year 3 when this is discovered and relief is sought, they still have to be a part of this election. And if they're unwilling to cooperate or can't be found, then relief under this provision isn't available. And if you don't meet this provision, you can still get a private letter ruling. More recently, Rev Proc 2022-19, and this revenue procedure is pretty great. In the essence, it resolves a lot of issues. And essentially, the IRS said, we're tired of receiving all these private letter rulings about these issues that people are concerned about, which we don't think have any bearing on terminating your S election. And one of the things that this revenue procedure focused on is the one class of stock requirement. And they say, essentially, if your entity had what they refer to as a non-identical provision, so that would be anything that doesn't provide for equal rights on distributions and liquidation, if your entity has one of these non-identical governing provisions and you haven't made or haven't been deemed to make disproportionate distributions and you filed tax returns, you're fine. They say amend your provision, and if we haven't, reached out to you before you do this, you're good. Don't worry about your S election. This is something that isn't even sent in. It's a statement that the entity fills out on its own and keeps with its records to be available should the IRS request it, but it's not something that's sent in with the return. And in this revenue procedure, the IRS, again, they say very clearly, disproportionate distributions do not affect your S election. The caveat of it with assuming you don't have non-identical governing provisions. So, one thing currently where people are unsure with this revenue procedure is, well, what if you have non-identical governing provisions and you've been deemed to make a disproportionate distribution, or you forgot to file a return? Technically, you're actually not eligible under this. The other thing this revenue procedure did is it said, here's some other areas that just don't violate an S election. And principally on this was, they say, again, disproportionate distributions. If you don't have non-identical governing provisions, disproportionate distributions will not violate the S election. If you lose or didn't receive your letter confirming that you had an S election in place, that's fine. If there were some certain, not all the signatures were on the original S election under this revenue procedure, it's not a problem. All right, so we've talked about what S corporations are and how they're taxed. Now to the real bulk of the tax certification exams. Again, entity selection. I took it in March. It was 12 questions divided into 2 3-hour 6-question blocks, and of each one of those 6-question blocks, one of them is, you pretty much just think of it as just like a super question. It's a huge question, and they're on entity selection and entity operation. And I'm pretty sure half of the point of possible available points on the election are, do you know entities and how they're taxed? And so a lot of things that you want to initially think about are, who are the people involved? What is the relationship? Are these family members? Are these at length business people? Are some of these people non-resident aliens? Are some of these people minors? What is the intended present ownership and management structure? Is everyone going to be highly involved? Are some people just going to be contributing money and just want to receive a check? How is the business activity taxed for federal and state purposes? Obviously, well, what is it doing? Is it a mining operation? Is it selling things? Is it services? Is it investing? What are the present and future plans? Is asset protection an issue for anyone involved? What's the size of the investment here? What's the potential for this to grow? Do the parties need third-party financing? How easy is it to obtain? Are there employees? Are the owners employees? Are we going to be addressing, FICA issues? Is this, and Section 199 Cap A, qualified business income deduction? Other things about, if your future plans are to, if the business ultimately plans to, go public on an exchange, how does this fit in with the principal's estate plans? Can ownership, is ownership and management, are they one and the same? Can we transfer ownership without transferring management? Does the operation of the entity suffer if ownership interests are transferred? Can interest be easily conveyed, easily valued? If we want minority interests to get discounts for income tax or state tax purposes, how easy is it to manage this entity, the structure? Can we take this structure apart without incurring significant tax effects? Is this a type of industry where we plan on having losses and we want the owners to be able to use those losses against their other income? Is there something involved? Is this a laundromat? This is a dry cleaning operation where there's a potential for a huge amount of liability, and we want to make sure it's segregated away from the owners. Is this something where federal or state security laws has come into play? So one of the prime things to consider is, the economics of the deal. How do these people want to share their profits and losses? Remember that the S corporation has this single class of stock requirement. All distributions and all liquidation proceeds have to be, equal per share. So if people come in and they want, a preferred return on their investment, or the clients are talking about, waterfall distributions or a return of their capital first before profits are shared, that's just incompatible with the S election. That's partnership. In corporations, you can also plan on having preferred returns, and in essence, a form of capital reimbursement. You have preferred shares and common shares, and the way that you structure the dividend rights. In partnerships, it's way easier. If these structures of, I guess, preferential treatment on profits, if that's something wanted, really the partnership structure allows you to do a lot more in accommodating that. S corporation just doesn't. The governing instrument itself. We talked about most new S corporations are LLCs. And a lot of times people just use the regular operating agreement, which is drafted for partnerships. And, that's violates the single class of stock. Now, again, there's a lot of revenue procedure 2022-19 doesn't make that a huge problem, assuming you don't do disproportionate distributions. But, if someone comes to you and they've already got an entity and it's an LLC and they go, I want to be an S corporation, before you make that S election, that operating agreement needs to be amended, should be amended. You can't have these 704B provisions, particularly the liquidating in accordance with positive capital accounts. Restrictions on transfers. C corporation, unless it's a closely held C corporation, it's not a huge deal. Partnerships, the transferable interest, there's a difference in the LLC structure between you have transferable interest, it's the right to distributions, and being able to partake in the management. They're not one and the same. So, transferable interest, that's fine. It doesn't mean that the existing members in the LLC or the existing partners in the partnership, that this new person isn't automatically involved in the management at all. It's just the rights to distributions. Well, in the S corporation structure, the restrictions on transfers are much more important because, again, a transfer that doesn't meet the requirements for an S corporation, transfer to an ineligible shareholder, violates the S election. And then everyone goes, assuming relief isn't sought, everyone goes from this pass-through structure to a C corporation structure. And on, C corporations, unless there's a dividend out to the shareholders, the tax impact is solely at the corporate level. And under both LLCs and partnerships and S corporations, the principals who are involved in that business, they're taxed on their shares of income, regardless of if a dollar comes out. So you want to sometimes think about, should we require provisions in the governing instrument to require that some amount of money comes out so that these people can pay tax on their share of the income? And how is that determined? That's actually, way more complicated than you would think. What's the nature of this business? Some of them are just kind of better suited to various types of entities. If real estate's involved, I don't think I can't imagine a good reason to ever put real estate in an S corporation or a C corporation. Because particularly we talked about how the shareholders in an S corporation do not get a basis increase for the entity's liability, whereas in a partnership, they do. So if real estate's involved, particularly if it's real estate development, really that's, in my opinion, that's more of a subchapter K. It's much more, that's a better area for it. If personal services are the prime income producing factor, for law firms, uh, doctors, accountants, engineers, things like that, subchapter S can be pretty good because we talked about how, under subchapter S, the wages that you pay to an employee, be it a shareholder employee or just an employee, yeah, those are subject to FICA. And again, look, you've got to pay reasonable wages or else the IRS will dispute that. But the distributions that go out to a shareholder owner aren't subject to employment taxes. They're not subject to FICA. How does the entity fit in with people's estate plans? There's, when it comes to corporations and partnerships, it's not a huge problem. But when it comes to S corporations, S corporations are very particular on who can be a shareholder. If we're talking about, estate planning with trusts, you have these time windows where a testamentary trust or a former grantor trust can remain permitted shareholders, but they're just time windows. They end. And, once that potential period's over, your trust has to qualify as more than likely either a QSST or an ESBT. And with the QSST, it's got to distribute out all the income. Do you want that? Do you want your benefit? Think of a QSST in essence as kind of a conduit trust. If you're talking about retirement plan, benefits planning, all the income has to come out. Does the principal want that? Do they want the income going out to the beneficiary? ESBTs don't have to do that. The income can stay in the trust, but it's taxed, trust tax rates, the brackets are compressed and the rates go up very quickly. So do you want that, have that tax incident, being at the trust level? Is this a type of business where you're trying to incentivize people with ownership? Is equity going to be granted in exchange for services? If you're talking about an S corporation or C corporation, you got to look at Section 83. For partnerships, I mean, in theory, Section 83 also still applies, but profits interests, they're generally not ever going to have a value. So granting profits interest in a partnership is almost always going to not be a taxable event. Think about the entity's profits. What are they going to do with them? Are they going to retain them? Are they going to distribute them out? If it's going to be retained in the entity, now the C corporation rate's 21%. You do have to think about potential excessive holdings taxes, but by and large, if the entity is going to retain its profits and reinvest its profits, particularly if the Section 199 Cap A deduction isn't extended, set to expire at the end of next year, then the rate differential between C corporations and partnerships and S corporations will be a significant factor. If the goal is to get the money, the profit that the activity generates into the hands of the owners, well, a pass-through structure is often going to be better because you're avoiding that double tax incidents. But remember, again, like in the pass-through regimes of subchapter K and subchapter S, the owners are taxed on their allocations of the income, whether they receive it or not. So if the plan is to get the money out to them, why not do it in the pass-through structure? Think of your state tax consequences as well. Florida taxes, C corporations, well, it was at 5.5%. I'm not sure what it is now. But not partnerships or S corporations unless the S corporation has one of these types of income which produces a entity level tax. Not all states follow that. Some states don't recognize S corporations, and that's pretty much it. So, again, when you're studying for the exam, really focus on entity selection. It's huge to know. I know the tax section is planning to do some more of these, kind of more focused on studying for the certification exam. Pretty sure Adam Smith did a primer on C corporations as well as a primer on partnerships in the past couple of years. I guess my advice for studying for the exam would be, if you think back about when you took the Florida bar exam, there was this whole broad list of things that they could tax you or they could test you on, but you knew in essence, well, they're not going to test me on all that. It's impossible. And if you look at the tax certification materials and they talk about, um, what you can be tested on, you should believe them. Because I looked at it, I was like, wow, that's everything possible in the world of tax. There's no way they'll actually test all of that. They do. Most of the emphasis is on entities, their life cycles, all the tax impacts of that. But, if you think, oh, I don't practice state and local tax, I'll roll the dice that they won't ask a question on that. They're going to ask a question on that. So take that seriously they're not joking when they say they're going to test everything. They're going to test everything on that list. General study suggestions or materials. I mean, I would really, so I found the Florida Bar Tax section has this YouTube page where this will be uploaded and where all the prior Zoom CLEs and even some phone CLEs going, back before COVID when no one was doing Zoom CLEs are. And I found those helpful, particularly for areas that I just know nothing about, like state and local tax. And the way I approach studying is going to be different for everyone else. Is I did my LLM program at the University of Florida about graduated in 2014. So I said, all right, I'm going to just look back through my notes from my classes and either, this, I know it's 10 years old, but I figured either if there's been a change, it's so important of a change that I'm going to know about it, or it's not important enough a change for them to ask a specific question on. And then, I would listen to these Zoom presentations, when I was, driving different places. And, I think that's a good combination. Again, everyone's different, and just take it seriously in terms of they're going to ask questions about all this stuff. Well, know what your strong areas are and your weak areas. Don't spend as much time on your strong area stuff. Like, they want to test a broad base, but not super in depth. I remember one of the things I did when I was going back through my corporate tax notes, I spent a lot more time on my corporate tax 2 notes on, the requirements of different forms of reorganizations, like a 368, a whatever cap C, the assets one. And they're not going to ask you super detailed questions. It's detailed, but they're, you don't need to spend as much time on corporate reorganizations as I will admit I did. But know your entities, know the life cycles of partnerships, S corporations, and C corporations well, and then just know what you're of the other things, know what you're strong on, know what you're not. You're not gonna, for me, state and local tax, know nothing about, and I knew I wasn't going to be great at it at the time of the test. But I watched enough Zoom CLEs where I felt like, all right, I can respond to what they're asking me. So, that's it. Good luck. Encourage all y'all to take the certification exam. And I'm not sure if these materials, one thing when I saw the materials, the Zoom CLEs, the presenters' materials weren't there. They weren't uploaded. I don't know if that's something that can change, but if you're watching this in December, planning to take the test in March, or you're watching in January, planning to test in March, if you want the materials, just email me. I'll send them to you. And good luck. So that's it. See if there's any more questions here. Nope.
All right, if there aren't any additional questions, I'm just going to repeat the CLE course code 8801. And thank you so much for presenting today, Daniel. That was a wealth of information that you shared with all of us.
No worries, all enjoyed it, and good luck to everybody.
Thank you. Participants, all of this information will be recorded and shared with you. So just a heads up. Thank you very much.